Welcome to Looking at Legal Stuff. Today we have 11 hearings in a case with a couple where dad is trying to establish a parenting plan that will allow him to see his child because mom has been keeping the child from him, claiming DV and substance abuse by dad. Mom claims dad barely has a relationship with the child. She says she wants substance abuse and DV evaluations done, and she wants supervised visitation if he must be given time with the child. Dad claims Mom is lying about most things, and anything that did happen between them has been exaggerated. He's willing to do anything the court requires, and he would ideally like 50-50 custody. Mom will try all sorts of things to keep Dad from seeing the child, including telling the court she should have full custody and Dad shouldn't have any visitation for the child's safety. Withholding the child from visitation because she claims she could tell he was high in a photo, and attempting to move away and relocate without giving Dad a chance to have any input. Is Dad as big a danger to the child as Mom claims? Let's see what the judge thinks.
Let's next go back to Roy Daly and Shariah Nelson. They've been waiting a very long time, 23-3-30408. I'll double check to see if they're still here. Hopefully we have Mr. Daly. I see that he's present. Thank you. Ms. Nelson, I see that
I'm present, Judge.
Oh, Mr. Brungard, are you here?
I am present, sir.
Great, thank you. All right, so let me just pull up my notes. We're here on Mr. Daly's motion for a temporary order. And I've received input from Mr. Daly and input from Ms. Nielsen, but just to be honest, I don't really have a clear idea what's going on with the case. We have kind of these general forms, and I don't really have any declarations that gives me any flavor for the dynamic or past involvement of parents in the child's life and the dynamic of the relationship and parenting skills, the living space, where people are going to be living or proposed to be living, ability to support information related to incomes, the viewpoint of really any depth from Ms. Nielsen. So that's kind of my initial reaction to reviewing the pleadings that were filed, is that it's not that it's wrong, but it's bare bones. And I need some more flesh on that skeleton, so to speak.
Yes, Your Honor. I actually have paperwork that I still need to file. I am asking the court to give me a continuance because I was not given enough time to respond back. On top of that, I also have another court case that I would like to be joined with this one. I filed it back in March.
And is it also involving Mr. Daly?
Yes.
And Paisley?
Yes.
What's the cause number?
Let me get that for you.
Okay, go ahead and take your time. Once you have that, well, I'll turn back to you. But while you're looking for it, I'll just touch base with Mr. Brungard.
Okay.
Your Honor, your observations are absolutely correct. I believe that it appears that the respondent is not prepared to move forward today. And I know that Your Honor is gone from the bench on the 10th and the 24th of this month. I was wondering perhaps if we could bring this matter back on the 17th of October and put some meat on the bones and put Your Honor in a better position of being able to make a decision that is in the best interest of this small child.
Okay, and again, just to clarify my schedule, I am here on the 10th and the 31st of October, but not on the 17th and the 24th. Just clarify.
Okay. That. Okay.
Oh, and the clerk has. Oh, go ahead.
What I would suggest, Your Honor, is I would have no difficulty coming back on the 24th of October.
Okay. So that's one day that I would not be present. So our options would be either the 10th or next week or the 31st.
Okay, let's go ahead, Judge, and if we may, why don't we go ahead, and if the mother does not object, let's come back on the 10th.
Okay.
I'm okay with the 10th. Your Honor, I do have the case number from when I filed.
Okay. Is it the 23-3-125-08?
Yes.
Okay. My clerk found that also, so I'm glad we confirmed that. One thing that I'd like to do is that we'll put both cases on to the October 10th docket, if we could do that. That will give me an opportunity to review them to see if they're of similar nature and if they should be joined or should be considered in conjunction. So we'll have them both on the docket on the 10th. I'll grant the motion. It sounds like it's a joint motion to continue. It's brought by Ms. Nelson, but there's no objection from Mr. Daly. So I'll grant that. We'll set it over to the 10th of October, where we can address the issues. It sounds like Ms. Nelson's going to file some information. And in filing that information, Ms. Nelson, do you think you could have that completed by the 3rd of October? Filed with
Yes, Your Honor, I sure can.
Okay. And then in filing that response, I think you're probably aware of this, but you'll need to provide a copy to Mr. Brungart in addition to the court.
Yes, Your Honor.
Great. That'll allow Mr. Daly the opportunity to reply if he would like. Okay.
Okay.
So with that, let me touch base with Mr. Brungart. Do you have any other issues other than coming back on the 10th of October?
No, the 10th is just a short time away. We will be prepared to argue on that date, Judge.
Very good. Ms. Nelson, do you have any additional items?
I don't at the moment.
Okay, great. We will reconvene on October 10th at 9 a.m. and we will discuss the issues presented.
All righty. Thank you, Your Honor.
Okay, thanks. And I see that Mr. Daly is on the line. Mr. Daly, can you hear me?
Yes, I can.
Okay, welcome to you. And Mr. Daly, are you expecting Mr. Brungart to be present today?
Yes,
Have you heard any word from him if he's on his way, if he's been delayed?
he is on his way. He could be in another court.
Okay. All right. So at this point, your matter is the final matter on my docket. So what I'd like to do is just take a brief recess and let's reconvene in about 10 minutes at 10:15. And we'll hope that Mr. Brungart is here at that time. Otherwise, maybe in between, Mr. Daly, you could get a status update from him to see if he'll be here at 10:15, and you can share that information with us when we reconvene at 10:15. Here on a motion brought by Mr. Daly or related to the parenting of the small child. So I've read the requests submitted by both parties in your pleading. So I'll hear from Mr. Brungart first as the moving party, and then I'll turn the time to Ms. Nelson to hear your position and your thoughts. So Mr. Brungart.
Judge, yes, I'm going to stand by the pleadings I have filed, but unfortunately, even though Your Honor cautioned the respondent about making sure I received pleadings, I have not received any pleadings by email, mail, or personal service, and so I have no idea what has been filed in this case.
Okay, let me touch base with Ms. Nelson. Ms. Nelson, as far as do you have any thoughts about Mr. Brungart's comments?
Yes, I have been trying to get it to him, but I don't know exactly what's going on with my phone. I have it scanned into my phone, but for some reason my email is not working. I have tried to fax it over to him from work, the work printer I have at my job, and the printer wasn't allowing me to. I'm a single full-time mom, so I, on my days off, am with my daughter all day long, meeting with the emergency support shelter, trying to figure out a lawyer to support me on my part.
Okay, so you mentioned it sounds like you scanned your documents that you had filed with the court. Have you tried to print them out and mail them to Mr. Brungart?
I have them printed out. I wasn't sure because I do have a yellow envelope that I can put them in. I wasn't sure if I am supposed to take them to the post office or if I'm supposed to just hand them over to the mail lady here at my house and then have her.
Yeah, you'd likely have to put them in the envelope, take it to the post office, weigh it, find out how much the postage is going to cost, put the postage on there, and then send it off then to Mr. Brungart's office. And then you'd have to take a second step of doing what's called an affidavit or a certificate of service, where you just say, hey, on such and such a date, I deposited this envelope that contained these documents in them. Then you list off the documents, and I sent it off to Mr. Brungart's office at such and such address, and then you'd file that certificate or affidavit.
Okay. So I do have them copied. I do have a copy for him. I just have to get it over to him.
Right. Okay. All right. Thank you. So let me circle back to Mr. Brungart. Mr. Brungart, knowing now it sounds like Ms. Nelson has a plan to get those documents to you. What is your position related to having the hearing today? Do you want to proceed, or do you want to wait until you get those documents from Ms. Nelson?
Well, my client has been waiting a very long time to have visitation with his baby. And so I am going to pursue moving forward today. And then after receipt of those, if I believe it necessary to ask the court to reconsider, I'm going to. But I would ask that we proceed today, Judge.
Okay. Ms. Nelson, do you have any concerns if we were to proceed today and make a decision on the issues and then potentially come back and take a different look at it after he's looked at your paperwork?
I don't see a problem with proceeding today, but I would like to have him have the paperwork first before even proceeding. That way he does have my part along with Roy's part.
Okay. You know, I think as a general rule, my take on this is that the system works best when all parties have had their opportunity to chime in and every party has had an opportunity to read what that other party's saying, and so that they can know exactly what their position is and be able to respond to it. It tends to be more efficient in that we wouldn't have to come back later on after we've addressed the issues and then go, okay, now we've got this information that was kind of already here but wasn't considered fully, and then kind of revisit a decision that we've already made. So that's one caution I have about hearing it today and moving forward today. That's tempered also by, you know, what Mr. Brungart said, that his client is interested in seeing his child and has waited a long time. So I'm weighing those two competing balances or interests, pardon me. Let me check with Ms. Nelson. As far as Ms. Nelson getting that envelope shipped out to Mr. Brungart, how quickly do you think that would happen?
I can have it to him this week.
Okay, so you could get to the post office today and get that mailed out?
Yes.
Okay. All right.
Your Honor is not available. I don't believe Your Honor is available next Tuesday, the 17th, as I recall from earlier court hearings. Is that correct?
Yeah, that is correct. The docket's still open. It'll still happen. Another judicial officer will be here.
I understand.
So I think we could probably...
Would Your Honor...
Go ahead.
Would Your Honor... I'm sorry. I apologize.
Oh, no, you're okay. You're okay. You don't get the benefit of seeing faces and movement and the like, so go ahead.
Would Your Honor be available on the 31st?
I am available that date, yes.
I can feel my client cringe, but what I'm going to suggest is we do it on the 31st, because even if I receive the material from the respondent today, I would still, I imagine, want to respond to any factual statements that she makes. And so that is going to mean that the 31st is probably the closest, most reasonable, functional date that we have available.
Thank you. Yeah, I tend to agree. I think that's a reasonable approach, and I appreciate that suggestion. Ms. Nelson, October 31st, how does that look for your schedule to hear this motion?
That works for me.
Okay. Well, I appreciate the parties' flexibility. Let's plan on that, October 31st at 9 a.m. Ms. Nelson will get those documents shipped out to Mr. Brungart, and so he can review them with his client, and if he would like, and then he could submit a rebuttal or a reply brief. And so I'll have read that, and we can fully argue the issue on the 31st.
Okay.
Any questions from either party?
No, Judge.
No, Your Honor.
Okay.
No, sir.
Very good. We'll reconvene October 31st at 9 a.m. Thank you for your patience.
Roy Daly and Shariah Nilsson, 233-30408 is the cause. And we'll see if those folks are present. Mr. Brungart represents Roy Daly. Mr. Brungart, are you on the line?
I am present, Judge.
Welcome, Mr. Brungart. And is Shariah
Thank you.
Nielsen on the line? Shariah Nielsen.
Yes, I am present, Your Honor.
Okay, welcome to you also, Ms. Nielsen. All right. Bear with me one moment while I pull up my notes. All right. Thanks for your patience. I appreciate that. This is a motion brought by Ms. Oops. Just one moment, sorry. This is a motion brought by Mr. Daly for parenting plan and child support issues. And then Ms. Nielsen, it looks like you filed some responsive declarations and pleadings. Did you provide copies of those to Mr. Brungart?
I have sent them to him. I don't know if he got them or not. I have not received any notification if he got them.
Okay, Mr. Brungart, did you receive the declarations that Ms. Nielsen supplied to the court?
Yes, Judge Evans.
Okay, great, thank you. All right, I'll hear from Mr. Brungart, and then we'll hear from Ms. Nielsen, please. Mr. Brungart.
Thank you. Judge, you reviewed our initial pleadings. Subsequent to that, we had my client file a supplemental, and I'm just going to primarily now respond to the materials that have been supplied to the court by the respondent mother. Want the court to realize that the respondent mother supplied some information regarding an incident that was investigated by the Longview Police Department. I can say to the court that that matter has been evaluated by the Caldas County Prosecutor's Office. It was subsequently referred to the Longview Prosecutor's Office. Both of those jurisdictions declined to bring any charges. I would imagine that it was due in part to the fact that if there was an assault in this case, it was de minimis. As Your Honor probably recalls, I'm certain, read the report. The worst allegation in that report is that, in fact, my client allegedly was storing things and allegedly hit her ankle with a nanny gate. There was also some troubling allegations that my client was armed with a weapon on that particular day, that in fact he was either threatening himself and or perhaps the respondent, but more importantly, after a very thorough investigation and the police report substantiate, my client denied having a gun. Any guns found that day, Your Honor, were in a safe, and the basis of all of this brings forth the fact that the respondent mother believes that before we move on in this particular case, that there would be a domestic violence evaluation done and that there be an alcohol evaluation done. Judge, I'm not going to mince words. These two people are not living together, and it's very obvious why. There's obviously a great amount of ill will, at least directed from the respondent mother to my client, and her concerns her concerns, even though important. There is no allegation in this matter that there's ever been any domestic violence, especially involving the child, even though the respondent mother in this case has submitted declarations that my client verbally demeaned her. That is supplied by the mother, it is supplied by the sister, but the record before the court is that it's absolutely devoid of any acts of domestic violence. Number two, regarding the alcohol, again, those are simply the reports of the respondent mother, and that concern can certainly be met in a parenting plan. The court can obviously order that my client during any period of visitation does not consume alcohol, and if in fact the respondent mother believes that she has a reasonable basis that my client has consumed any alcohol, that can be addressed by her in the court. But again, I believe the directive from the court to my client would be more than sufficient to ensure the safety of this minor child. There has been some reports that from the respondent mother that there is very little past contact between my client and the child. I believe that was refuted very fully in his declaration, where he supplied, and I have always been told that pictures are worth 1,000 words. The pictures that we submitted to the court, though they are in black and white, it is very obvious that this child, during the period of time that my client was with the respondent mother, that there was a significant relationship. He indicated that he cared for the child. He cared for the child when the respondent mother went to work. And if the respondent mother was not available, he was, in fact, the primary caretaker for this child. All in all, Judge, I believe that it's appropriate today, after these many months. My client has been very patient. He's been a very calm individual, a very sensitive individual to the court's needs, to my needs, and more importantly, to the best interests of his child. I believe it's time at this point in time that we move forward, that we initially go with a day visitation for the first 4 weeks, that either on Saturday or Sunday, as the court designates, that he would have contact with that child from 9 o'clock in the morning until 5 o'clock at night. Upon the completion of that 4-week period of time, assuming that there are no concerns expressed, that we move then into a overnight mode for a weekend. We do that for 4 weeks, and then at the conclusion of the 8 weeks, we go back to what my client is seeking, and that is a 50-50 visitation schedule shared with the respondent mother, where my client would have an opportunity to be with this child 50% of the time. I believe that should satisfy some of the court's concerns, but if you have any questions, Judge Evans, I am here for any questions, any queries that you have. Thank you.
Thank you, Mr. Brungart. I don't have any questions for you at this point. I'll hear from, please, Ms. Nilsson.
The police reports that I did turn in, the guns he did have in the safe were taken into custody. The gun that he had used that night, we were not able to find, which turned his, I guess, police hearing custody thing into a misdemeanor because we could not find the gun. He did stash it somewhere. I have torn the house inside out, upside down, to try and find that weapon that he used that night for the police, and because it was not found, that's why it turned into a misdemeanor. The baby gate was not thrown at my ankle, it was thrown at my shin, and there was a bruise there for about a week and a half. I was in counseling at that time and had been now out of it for quite some time due to being busy with my daughter and work. The only time Roy had seen Paisley was the time he got off of work, when I got home, and on weekends when I did have to work. And at that time, she would even cry for me not to leave because she did not want her father. On top of that, the incident before that, my daughter was in my arms and he had spat in my face. My parents lived with me at that time, and my mother was there. My family has seen the abuse and has been there for me since it all started. Of course, he's going to say that it did not happen, but I have pictures for proof of marks on my body that he has left. My daughter has trauma from it, and we both are now at this point having hard time sleeping throughout the night due to such trauma. My daughter is very important to me. She always comes first. Even if I was at work, I was always checking up on her, making sure everything was all right, and have told people who did watch her, if they need me, call me and I'll be there ASAP. A lot of the time that he would have her, he would often have his family watch her due to him wanting to go fishing and be with his buddies when it was his time to be with her. So at this point, I do want supervised visitation and
Can I ask you a question on that point?
yeah,
Do you have a suggested supervisor?
I do. She used to be I believe a paralegal. So she has experience in being a supervisor for parents. Her name is Tara Hargrave.
And does she charge a fee?
No, she doesn't. She is willing and able to be there.
Okay. All right. Thanks. Go ahead, please.
I have always been in my daughter's life. He has told me that I baby her too much, and I'm around her too much, that I need to stop babying her, and such and foremost. Like I said before, my daughter is number one priority. So he has often not been around her throughout her life. Most of the time he's not home until roughly 5-6 o'clock in the afternoon, unless it was a Friday, then it was about 3 or 4 o'clock in the afternoon. Even when he was home, when we were together and living together, he'd instantly go for the fridge for a beer or sit down and play video games while I'm taking care of my daughter. I personally don't think that 50-50 custody is okay at this point in time until he can prove that he is fit and able to be a parent to her. And I do want the alcohol and drug evaluations done, and would like the court to receive proof of the alcohol and evaluation, and they're not to have that around her when he is visiting her.
Okay. Thank you. Mr. Brunkard?
Judge, we're ready to proceed.
Thank you. All right. My sense here is that what I'd like to see happen here is for there to have Mr. Daly get a substance use disorder evaluation and also obtain a domestic violence evaluation. And until those are completed and we see what the recommendations are, that I think there should be some supervised visitation for the father. It sounds like there hasn't been much, and I know that there's concerns on Ms. Nilsson's end, and yet it's important that contact continue. And I guess I wanted to ask Mr. Brungart, Tara Hargrave sounds like an interested third party that could serve as a supervisor at no cost. Do you or your client have any input on that person?
As long as she is a neutral third-party person who's willing to do this without a professional fee, we would adopt her, and I would just ask the court to inquire as to the proper spelling so I can include that in the order.
Thank you. Ms. Nelson, how do you spell Tara Hargrave's name?
First name is spelled Tara. Last name is spelled Hargrav as in Victor E.
Okay, great, thank you. So until those evaluations have been completed, I'm ordering that there be a midweek visit of 2 hours. That could be between 5 and 7 p.m. If the parties can't agree, if you want to do it earlier, that's fine. But if you can't agree, then it'll be Wednesday, 5 to 7. And I'm fine if you agree to change it to a different date if it works better for everybody's schedule. But if you can't agree, then it'll be Wednesday, 5 to 7, 2 hours every week. And then 4 hours on Saturday, noon to 4. Again, the parties can change that to a Sunday and the hours can be different. But if you can't agree, then it'll be Saturday at noon to 4. That'll continue until we have a hearing when the evaluations have been brought back and are before the court. And we'll see what the evaluations recommend. And then we'll take a look at what the next steps would be as far as parenting time for Mr. Daly and the child. So at this point, I'm not planning on setting a hearing date. There's a lot of time and effort to get those evaluations, and I don't know how long it's going to take. It's somewhat imprecise. Once those have been completed, I would anticipate they would be filed under seal and copies provided to all parties. And then we can then it could be noted up for a hearing and take a look at those. It should be noted also that for the domestic violence evaluation and the SUD evaluation, that collateral input will be given by Ms. Nilsson and others, but definitely Ms. Nilsson. And so that means Mr. Daly would need to sign a release of information allowing for Ms. Nilsson to receive provide that input to both evaluations. So that's where we are with today's decision. We could take a look at coming back next week as far as a presentation of that order, or we could take a look at 2 weeks. Any preference?
Judge, let's do 2 weeks, sir.
2 weeks?
The 14th.
Okay, November 14th works for me. So, Ms. Nilsson, my proposal is to come back on November 14th. Mr. Brungart will draft up an order from today's hearing, which requires the domestic violence evaluation, the SUD evaluation with collateral input from yourself, and that the listing of the visitation times, Wednesdays and Saturdays, for the time specified. That's what the order will say. And then we would be here on the 14th to review it and sign off on it. And then a future hearing would be determined later once the evaluations are done. Any questions, Ms. Nelson?
When would the visitations start? Like, how soon would they start?
Next Wednesday.
Next Wednesday?
Yep.
Okay.
So that would be what's that, next Wednesday? The 8th.
November 8th? Okay. And then within that time period, I would receive the paperwork from Mr. Brungart and Roy for the evaluation and visitation paperwork for us to sign off on.
Yeah, he'll provide you a copy of what his proposed order is, and then when we're here on the 14th, if you have any concerns, you can air them at that time.
Okay.
Okay. All right. Mr. Brungart, any final items?
The final item is, I don't believe that the respondent has an address at this time. Would Your Honor inquire so I can send by certified mail and or, regular mail a copy of the proposed order to what address?
Yeah, let me ask Ms. Nilsson, in your recent pleadings, you used an address in Longview on 8th Avenue. Is that the good address?
Can I have it sent to a different address?
You can, and would you prefer providing that over, because everything's being streamed live via YouTube. Some people have sensitivity to that, or if that's something that you could provide an address to Mr. Brungart over this medium or through a phone call, or what's your preference?
What's his email, and I can email it to him.
Mr. Brungart?
I would prefer, Judge, I would prefer that you text me that address, and I have no qualms about giving out my phone number. And if Your Honor will just tell me when she's ready, I'll give her my cell number for a text.
Will that work for you, Ms. Nelson, if you text it to him?
Yes, that would work.
Excuse me. Go ahead, Mr. Brungart. Great. So
I
if you,
will
you could,
get that address sent over to you as soon as I can.
great. And then also
Thank
be
you,
aware,
Judge.
one item, be aware, Ms. Nelson, that if you need to keep an address updated with the court so everybody knows where to send documents to you. So if the 8th Avenue address is not a good address anymore, you could be served papers at that location. And if you're not there, then you're not going to receive notice of a hearing. So it's important to keep your address updated, just to give you that little FYI.
Yes, Your Honor. I wasn't sure how to exactly go about getting address to the court.
You can check with the clerk's office and you can file basically an updated address. They'll give you a hand with that.
Okay.
Okay, great. All right, thank you all. Appreciate that. We'll see you in a couple of weeks.
Thank you, Your
Thank
Honor.
you.
See you.
Thank you, Your Honor.
Thank you.
Roy Daly and Shariah Nielsen, 23-3-30408. Mr. Brungart represents Mr. Daly. Mr. Brungart, are you on the line? All right, and Shariah
Yes,
Nielsen.
Judge, I am on the line.
Okay, great, good. Thanks, Mr. Brungart. And then Ms. Nielsen, are you on the line today?
Yes, I am.
All right, very good. We're on today for a presentation from an earlier docket, and looks like Mr. Brungart's office prepared a proposed order. And Ms. Nielsen, did you receive a copy of that order?
I did.
Do you have any concerns that it doesn't accurately reflect what the court ordered?
So on number 4 on the second page,
Okay,
it says that she's a year and 10 months old. That is incorrect. She is 2 years old.
okay. Mr. Brungart, any opposition to change then that to 2 years?
No, please, Judge.
It's corrected. It says 2 years now.
Okay. And then also on number 4 on the third page,
Okay.
it says that the petitioner and respondent must not take the children out of Washington state. I have family that's out of state, and would like to be able to go and see them with my daughter. My sister lives in Idaho, and then I have a cousin that lives in Nevada. So I believe that I should be able to take my daughter to go see my sister and my cousin when upon visitation.
Okay, Mr. Brungart.
No objection to striking.
Okay. Number
Let
5.
me ask if I could, Ms. Nelson.
Yeah.
There, on that number on page 3, where it says petitioner and respondent must not take the children out of Washington state, Mr. Brungart proposed that we just simply strike that provision. Are you comfortable with that?
For the petitioner, I believe he should stay in Washington state. I don't believe he has family that he goes to see outside of Washington state.
Okay, Mr. Brungart.
No, Judge, if what's good for the goose is good for the gander, if we're going to strike it, let's strike it all together. In fact, I don't believe the court even they made a ruling on that particular point. Thank you.
Thanks. Ms. Nelson, do you, at the hearing, I do not recall, I don't specifically recall making a ruling on that particular provision. Is it your position that I did make a ruling on that, or is just that?
I believe I did have it in my parenting plan from the beginning, and it was not brought up in the last hearing.
Okay. And in your proposed parenting plan, you were proposing that Mr. Daly be restricted from removing the children, but you were not restricted. Is that correct?
Yes.
Okay. Just one moment. I'm just taking a look at that proposed order that was filed, at least by Mr. Brungart. He filed a proposed parenting plan.
Yeah, the parenting plan that I'm talking about is the one that I filed back in March. And then I had to go and file another one in response to his parenting plan when I turned into my declarations.
Okay. I'm going to revise at the top of page 3 of the proposed order. I'm revising it and indicating that petitioner must not take the children out of Washington State and removing the restriction on the respondent. Okay, if you'd like to move to your next item, Ms. Nelson.
Okay, number 5, we both requested child support. I have taken care of Paisley since day one, basically by myself. Since we have split up, I have not received anything from Mr. Daly. No diapers, not
Ms. Nelson,
even.
can I chime in? So
Yes.
I looked at the minutes from our last hearing when the court made its rulings. There was we didn't address child support at that time. The court did not make a ruling on child support.
Correct.
So at this point, was there a specific request made? Because otherwise, I'm just going to say it's reserved, which means that the party's going to address it at a later time.
Yes, I believe in my parenting plan with the declarations that I turned in, I requested child support from Mr. Daly.
Okay, so I'm just going to reserve on the issue of child support. I'm just going to write in the other line and say reserved. Okay.
All right. Let's see here. Number 12. It says no request made. I believe when I responded to his parenting plan after being served with it, I requested that the petitioner pay at least $3,000, I believe, for lawyer fees when lawyer is, I guess, requested and present.
Okay, and so we did not address that at the last hearing, correct?
Correct.
Okay. So I'm going to, at this point, I'm just going to say that the request is reserved. You can address it at a later time.
Okay.
And other concerns?
Number 13 on, I believe, the second to last page. The restraining order. I did request a restraining order from Mr. Daly.
Did you request it in this cause number, the 233304?
I believe I did.
In which document did you make that request?
On my parenting plan that I turned in.
Okay. And at the last hearing, did we address that issue?
No, we did not.
Okay. I'm just on that issue also, I'm just going to simply indicate that that issue is reserved.
Okay. Number 14, where it says the supervisor shall be Tara Hargrove. I did spell her name out in the last court hearing. It is Hargrave.
I'll make that change. Any other concerns?
If Mr. Daly has gotten appointments with evaluators, when are they? And who are the evaluators?
I don't know. They just need to be somebody who's credentialed and licensed to do that type of evaluation. So the indication in the proposed order is that the evaluations will be collateral, which means that you will have opportunity to provide information to the evaluator. So therefore, they'll speak with you, and therefore you'll know who they are.
Okay. When he does have his evaluations, I would like to be messaged about that, since his lawyer does have my phone number. If he can let me know as soon as he gets them, that would be good to know, because then I can go from there.
Okay. Yeah, I think with the order is pretty clear that any evaluations that will be undertaken by Mr. Daly, Ms. Nielsen will have opportunity to provide collateral input. Therefore, they'll either reach out to you, the evaluators themselves, or you'll receive some type of messaging. They're the ones that are going to be driving that. So I think I'm not going to make any adjustments to the order. I'm just going to go ahead and, with the adjustments that we've made, I'm going to go ahead and sign off on that. And then I'll just ask if the parties have any additional questions or concerns. Mr. Brungart?
No, Judge. Thank you, sir.
All right. And Ms. Nielsen, any additional questions or concerns?
So I would like to say that since the visitations have started, Paisley's demeanor.
So I'm
Granted,
just going to interrupt. I'm going to interrupt again. I apologize, Ms. Nielsen. So we're on today for a presentation from the prior order. So any issues related to basically anything else that's not on docketed, we generally don't address those issues right now. We wait until there's something that's been docketed. So for right now, we've accomplished what we were set out and everybody's planning on. So if you have any concerns related to the visitation, you can certainly note that up with some type of motion or request for relief or change.
Okay.
Okay, great. All right. Well, thank you. That'll conclude the hearing for today.
All right. Thank you.
Thank you, Judge.
I'd like to call next the Roy Daly and Shariah Nelson matters. These are respectively 23-3, 304, and 125, both ending in 08. I'll ask if Roy Daly's on the line. Mr. Daly, if you're on the line, make sure you're unmuted and state your name.
Yes, Your Honor, I can hear you.
Okay, welcome to you, Mr. Daly. And I'll ask if Shariah Nielsen is on the line.
Yes, Honor, I am.
Okay, welcome to you, ma'am. All right, we're on today, and Ms. Looney is present. We're on today for Ms. Nielsen's motion related to temporary order. First, let me just ask, Ms. Nielsen, did you serve Mr. Roy any documentation related to your motion?
So at the time when I filed and sent it off, I had sent it to his lawyer he had, and just found out probably about a week ago, week and a half, that he no longer had a lawyer. I wasn't exactly sure how to go about that, seeing as when I sent off the papers, I sent it to his lawyer he had.
When you sent off the papers to his lawyer, did you fill out what they call either an affidavit or a declaration of service indicating that you had mailed that off?
I believe so, yes.
Okay. When I checked the file, I didn't see that. So I'll double check again. And again, we're addressing the cause number 125, the 23-125 cause. So reviewing that file, and also double check the 304 matter to see if it may have been filed there. I don't see it there either. So that declaration or affidavit of service is the way that the court knows that somebody has mailed something or has served somebody with documents, and without that, there's not evidence that that has been served or given to the other
Okay.
side. So at this point, without service on Mr. Daly, we're not in a position to go forward. You would have to make service on him of the documents related to your motion, and then you'd have to docket it for a future date.
Okay, do I have his lawyer that he had send me back the copies that I sent him?
You could certainly check with the attorney. I don't know whether the attorney would still have those documents. They may not. I kind of doubt it, but you can certainly check with Mr. Brungart.
Okay.
All right. So any questions on that, Mr. Daly, on that particular matter?
Your Honor, I also have a quick question before we go.
Yeah,
How
a little
would I possibly get papers to Roy?
Nelson. So I had a question for Mr. Daly. Mr. Daly, do you have any questions on the stance of the case?
No, Your Honor, I do not, but it would be nice to have those papers.
Okay. Then Ms. Nilsson, you had a question?
Yeah, how would I get him the papers?
That's something that you can check on washingtonlawhelp.org. That's a valuable resource that you can check on how to serve people documents. Another resource would be the CLEAR hotline, CLEAR. That's a line staffed by licensed attorneys, and they can give you some legal advice on how to serve people.
Okay, and I currently don't have his address either. So if I, like, when I do get him served, I have no known location for him.
Okay. Mr. Daly, have you filed any documents in the case?
No, I have not, Your Honor.
Sometimes people, when they're involved in a legal matter, will ask for or will agree to service by email. Some people will agree to email service so they have the documents so they know what's going on so they can be prepared and defend against any particular matter. What do you think about that?
Yes, email would work for me.
Okay. Some people feel comfortable sharing their email over Zoom, others don't. What's your preference?
I can do the email. I personally would rather have him have the paper copies.
The question was posed to Mr. Daly. What's your preference?
I'd rather have it emailed.
Okay. And do you, as far as preference, sharing it, your email address over Zoom? In other words, are you comfortable doing that or no?
Yes.
Okay, go ahead and share your email. All right. Ms. Nelson, did you get that?
Yep, I got that.
Okay. So if you will serve a copy of those documents on Mr. Daly, then then file an affidavit or declaration of service and file that with the court, and then docket it for a future date, and then we can be back here and address your motion.
Okay, thank you.
The other matter we need to address before you leave, Ms. Nelson, relates to Ms. Looney's involvement in the case. Ms. Looney?
Thank you, Your Honor. So we have filed a motion for temporary child support orders. We have asked for that to be set for April 24th. My understanding is that there was no request to address child support today.
Okay.
The other question I had for Your Honor is whether or not we would be consolidating the cause numbers. It appears that the most recent filings were done in the 304 cause number rather than the 125 cause number. That's where we had filed our motion as well. So we weren't sure which cause number would be the accurate one to use.
Yeah, let me touch base with Mr. Daly and Ms. Nielsen. There's competing matters that have been filed. So the first is the 125 case. That's where Ms. Nielsen has filed a petition for a parenting plan and child support. And then in the 304 case, That's a matter that was filed back in July of 2000. Actually, let me hold on a second. I think I messed up there. Yeah, sorry. Let me go back. Let me restart. So back in March of 2023, Ms. Nielsen filed her petition for a parenting plan and child support. And then in July of 2023, Mr. Daly filed his motion via Mr. Brungart for parenting plan and also child support. It's the same issue. We're dealing with Paisley and her best interests and the parenting plan there. Does either party have any concern if we were to consolidate the cause numbers into a single cause number, which basically just merges them into one file? Everything that's been filed before continues to be filed and is available to the court and to the parties to review. It just makes it administratively a little bit easier. So there's just one cause number. And all the issues that each of you have raised would be addressed. So does either party have any questions or concerns about that? Mr. Daly?
No, you're not, Your Honor.
Ms. Nielsen?
No, I'm fine with that.
Okay. And then Ms. Looney, you indicated that the most recent motions were filed in the 304 case. Is that correct?
Yes, Your Honor.
Okay. Any strong preference, Ms. Looney, as far as which one is the receiving case?
If we could do the 304, that's where we've already filed our paperwork, and that's the cause number we're operating under. If the parties don't have a preference, that would be ours. That has the most information in it currently.
Okay. And again, like I said before, all information that's been previously filed in both cases would be available to the court. So I'm fine with that. The 304 case will be the receptacle of the 125 pleadings. So from here on out, we'll work with the 23304 cause. Ms. Looney, would you be in a position to prepare and submit an order of consolidation and submit it to the court and provide copies to parties?
Yes, Your Honor, we can do that.
Okay, great. Thank you. And then also, Mr. Daly, I see that there was I think there's an address let's see, address on 19th Avenue. Is that still a good address?
For mailing, it would be, Your Honor.
For mailing, it would be, you say?
Yes.
Okay. So Ms. Nielsen, that's also another option for you. You can serve via email as indicated by Mr. Daly, or you could serve via mail at the 19th Avenue address.
Okay, thank you.
All right. With that said, we have then Ms. Looney's matter that's been docketed and for the April, tell me again the date.
24th, Your Honor.
So we'll be back at least on the April 24th to hear Ms. Looney's motion. As far as Ms. Nielsen's motion, make sure there's that service, and then you file that affidavit with the court. And then we'll look forward if Mr. Daly has any response, then we will be back here on a date docketed by Ms. Nielsen. So we'll see everybody in the future.
Okay, thank you.
Thank you, Your Honor.
Next, I have Roy Daly and Shariah Nielsen. 233-30408 is the cause number. We'll ask if those parties are present online. Let's see. Ms. Looney is present. She represents the state. And let's see. Shariah Nielsen, are you on the line?
Yes, Your Honor, I am.
Okay, welcome to you. And Roy Daly, are you on the line?
Yes, Your Honor.
Okay, welcome to all of you. We're here on a variety of motions. The state has filed a motion related to temporary child support. And Ms. Nielsen has filed a motion related to a parenting plan. There's also was notice given related to a proposed relocation. So the relocation, maybe we could just start with that. The relocation, that we're not going to hear that today because service of that notice of relocation upon Mr. Daly occurred on April 1. We need to wait at least 30 days for Mr. Daly to file a response. So the earliest it could be heard is on May 1st. So we will not be hearing the relocation matter this morning.
Okay.
So that's as far as that. I just want to make sure everybody's clear on that. Any questions on that, on the relocation? Well, we're holding off on and we're not hearing that today.
Your Honor,
Yeah, go ahead, Mr. Daly.
I've consulted an attorney, and so I would they need more time for her to read the paperwork and get back to it. And she's on a vacation today, otherwise she would have been here today.
Okay. Yeah, right. At this point, it's the relocation. It was noted for today. However, we're not going to hear it today, so it'll have to be renoted for a different day. So the party who's seeking the relocation would need to add it to a docket at a future date.
Okay.
So let's focus our attention first on the child support, where the state is moving for child support to be calculated based on the parents' incomes and child support to be ordered. So I'll first hear from Ms. Looney and then hear from Mr. Daly and Ms. Nielsen.
Yes, the state is requesting a temporary child support order because the child began receiving TANF in January. We did use Mr. Daly's income from 2023 for all 4 quarters to come up with a net monthly income of $43.82 for him. And because Ms. Nielsen is currently receiving TANF, we did impute her wages at minimum wage 32 hours a week. We came up with a transfer payment of $733 from Mr. Daly to Ms. Nielsen that we are requesting begin in January of 2024.
And your proposed start date, again, you said was January?
Yes, Your Honor. We also received no written response or communication from either parent stating that they objected to our order.
Okay, thank you, Ms. Looney. Mr. Daly, did you receive the proposed motion or the motion and the proposed orders and documents from Ms. Looney?
No, I've not. The only documents I received was on the first from Shreya.
So you said you did not receive it, and then you said the only papers you received, and what was the last part?
On the 1st of April.
Okay.
And there's my email.
Okay, let me just take a look. I'm looking in. Okay, it looks like on May 19th, pardon me, March 19th, 2024, an assistant of Miss Looney mailed those documents to your address on 19th Avenue. Are you still on 19th Avenue, Mr. Daly?
Yes.
Okay. And then Ms. Nielsen, did you receive copies of those documents from Ms. Looney?
Yes, Your Honor, I did.
Okay. So, Mr. Daly, the documents that were sent to you were a notice of appearance from Ms. Looney announcing that she's part of the case, a response to the petition in the case, sealed financial source documents, a proposed child support order, and also worksheets, a motion for temporary family law order, and a notice of hearing. And that notice of hearing set today at 9 o'clock as the time and place for that. So, Mr. Daly, did any of those documents that I mentioned, do any of those ring a bell, or have you seen any of those?
Yeah, I believe like I remember seeing how much we make and where we work at, the history.
Right. Okay. All right. So it sounds like you did get those documents that Miss Looney's assistant sent out to you. Did you file anything in response, Mr. Daly?
No, I have not, Your Honor.
Okay. Let me touch base with Miss Nielsen. Miss Nielsen, did you file anything in response to the state's proposed orders?
No, Your Honor.
Okay. So maybe I'll just go in reverse order. Ms. Nielsen, do you have any objection to the state's request related to child support?
No, Your Honor, I don't. I will say though, I haven't received any child support since back in March when we separated.
Mine doesn't taste like they put the gold in.
So just pardon me, just a friendly reminder to all that are on the Zoom call, make sure that your phone is muted or your tablet or your computer. Look for the icon that looks like a microphone. You can press that, that'll mute and unmute. And then if you're dialing in using a phone number, you can press *6, that will mute, and then *6 will unmute. Thanks. Sorry for the interruption. Mr. Daly, what's your position related to the state's figures as far as monthly income and the proposed child support payment? Mr. Daly?
Yes. Yeah, 733 is what was wrote down what I'd have to pay, and I have rent, my own bills, and the cost of living, and is wanting to consult my attorney about this matter and touch bases back.
Do you, as far as your net income, does that look about right? The state put down 4,300 net per month.
Yes, Your Honor.
Okay. And then they put down for Ms. Nielsen an imputed amount of 2,035, which is full-time minimum wage. Do you have any concerns with that figure?
No, Your Honor.
Mr. Daly?
No, I did not. But my checks vary month to month, and some checks are better than other checks, and some months are not so great for work.
Right. Right. And let me double check with Ms. Looney. Ms. Looney, you used, was it the employment security data information that you used to come up with that figure?
Yes, Your Honor, we take all 4 quarters and then we find the average income per month based on the yearly income.
So it's you basically you're analyzing 12 months. Is that where your figures come from, the employment security data?
Yes, Your Honor.
Okay. So I think so, Mr. Daly, like you said, you know, your income varies. And so what Ms. Looney used numbers from the Employment Security Department's database that takes into account the prior years and then averages it out to prior year, pardon me, and averages out to a monthly support amount. And that's where she came up with that 4,382. So, so at this point, it sounds like both parties have received notice of what the state's proposal is. Both parties indicate that they're comfortable with the net incomes that Ms. Looney has proposed. And what happens with those net incomes, there's an online calculator that everybody uses to calculate support. So the net incomes are inputted into that, and it's a calculation, and it kicks out a number. So I recognize Mr. Daly indicated he wanted to talk to an attorney about this. He was given notice some time ago, and also, you know, the numbers aren't going to change. You know, as far as like once you input the numbers, it's going to kick out the same number. I mean, there may be quibbles on, you know, whether it's 4,380 or whether it's 4,400 or 4,300 flat, but as far as the numbers that come out, they're not going to be dramatically different. So I'm going to grant the state's motion for the child support and have that start on January 1, 2024. And then those child support, I think those support payment, pardon me, the child support worksheets in order, Ms. Looney, those were, did you supply those to the court? I can't remember.
Yes, Your Honor. We did send those over on the 16th.
Okay, let me see. I have them here. Okay. Ms. Looney, I don't see them here. Let me look just one more time. I see some proposed orders that Ms. Nilsson had filed, but let me just look one more time just to be thorough. Okay, yeah, it looks like I don't have them, Ms. Looney. I apologize. Was that something that you could resubmit those documents?
Yes, Your Honor.
Okay. So Mr. Daly, Ms. Nielsen, what will happen next? Ms. Looney will send the same copies of documents that she sent to you. She's going to resend those to me for my signature. I'll receive them, I'll sign them, and then they'll be filed with the clerk. So any questions on the child support issue?
No, Your Honor.
Okay, Mr. Daly, do you have any questions?
No, Your Honor.
Okay. All right. That will take care of that portion of the motion. The next.
Thank you, Your Honor.
All right. And then the next is related to Ms. Nilsson, your motion for a temporary parenting plan. And let me make sure, Mr. Daly, it looks like when we were here on the 27th of March, everybody agreed to serve each other via email. And so Ms. Nilsson filed a document where she indicates that she filed the proposed documents related to her motion for temporary parenting plan to you on April 1st via email. Did you get a copy of those?
Yes.
Okay. And so I wanted to double check, Mr. Daly, there's Ms. Nilsson indicated some of her concerns and things that she wants to see in the parenting plan and things that she doesn't want to see in the parenting plan. And the indication that I got from you, the response that I got from you was that it looks like you had completed a substance use disorder evaluation on February 26th, and that there is no treatment recommended, and there was collateral contact with Ms. Nilsson in making that evaluation and that recommendation. Did you file any additional information related to the parenting plan?
No, Your Honor, I have not. I was trying to submit papers towards like the movement with the child, but it hasn't been submitted in the courts, I was told yet, and I would have to pay to submit them. And so I didn't submit them because the clerk, Superior Court clerk, was telling me that it hasn't been submitted in the courts. But I'm trying to submit it though.
Did you say that you said you felt like you had to pay something to file?
Yeah, because it hasn't been submitted in the courts, I was told, and that you'd have to pay to submit them.
If the notice for relocation has not been filed and he wants to file an objection to it before it's filed, there is a $56 fine.
Okay. I was under the impression that there was a notice of intended relocation filed, so that was filed on February 27th. So, Madam Clerk, if that was filed, then there would not be payment? Okay. So, Mr. Daly, as far as the relocation issue, the notice has already been filed by Ms. Nielsen. That means that there would be no payment required to respond to that. So you could file any documents or pleadings you'd want stating your position without paying anything.
Okay.
So that's the relocation, which we're not talking about at this point because it's premature because the 30 days has not yet elapsed from the time that you were served with a copy of that document. So we're focusing on the parenting plan, and there's a current plan in place basically where from back in November that you have supervised visits with the children or child on Wednesday from 5 to 7 p.m. and Saturday noon to 4 p.m. and they're supervised, and that you needed to get an SUD evaluation and a domestic violence evaluation. So are you in agreement with that continuing, or are you wanting something different? And if so, did you file anything to express that desire that you have?
I would like them to continue, but I've not submitted anything. I filled out the paperwork, but I was having trouble submitting them, so I haven't submitted anything yet.
Okay. So you said you're having trouble submitting them,
Yes.
such as?
What's that, Your Honor?
When you said you had trouble submitting them, what's the difficulty you're encountering?
Submitted them into the clerk. I had trouble, because I thought I figured I had to pay to submit them. And, but I have the paperwork filled out.
Okay. All right. Okay. Thank you.
And I was consulting my attorney, and I was, had a meeting last week, but this week she's on vacation.
There's one thing I want to do this.
Okay. All right. Thank you. All right. So, Ms. Nilsson, you submitted a proposed parenting plan where you, just a moment, where you're indicating having 0 visitation or residential time for Mr. Daly. Is that accurate?
Yes, I would like to go for full custody.
Okay. And have Mr. Daly have 0 contact with the child?
Yes, Your Honor.
And that's based on the child being returned late and the father not changing diapers and concerns about inebriation or being drunk during visits.
Yes, Your Honor. There has been quite a few times where he has shown up under the influence to the visitation. The pictures that I have submitted with the documents, one shows where he is high, and then the other one also shows where he is high and has alcohol in his system. I feel that is not safe for my daughter to be around, hence the situation that we went through back in March of last year. I personally don't think that she should be around that, risking her safety.
Okay. Let me ask you a question. The visits are supervised, are they not?
Yes, they are. And I
And
have spoken with the supervisor about it on numerous occasions. And I told her how I felt about them, but unfortunately, she allowed them to continue.
okay. And then you if I understand correctly, you were not present during the visits, and you're looking solely at photos of Mr. Daly, and you can tell by those photos that he's high or drunk.
Yes, Your Honor.
Okay. Okay. Mr. Daly, anything else you want to comment on?
Yes, those are supervised visits, and I do not pick up my daughter for visitation or drop her off during visitation. So there's no way I could have dropped my daughter off late or picked her up late. And I've been accused of being drunk and high on visitation, which I have not been.
Okay. All right. So one of the things that I encounter on sometimes in the self-represented family law docket is that it's a very complex thing to do all this legal stuff and file papers and have a good clear idea how things are going to turn out, or have, what's important to be considered. What I do know is that there is a parenting plan that was entered in November of 2023. Ms. Nilsson has raised concerns related to diaper during the 2-hour visit. Diapers don't get changed on occasion. That these are her concerns. The child is returned late, sometimes up to an hour, and that Mr. Daly is either drunk or high at some of the visits, and he hadn't completed the SUD evaluation, which we have proof that he has completed that. And we also know that the visits are supervised, and the supervisor has not ended the visits due to concerns for the safety of the child. So what I'm going to do at this point is I'm going to appoint a family law investigator. It's our family court investigator. Her name's Jen Schaefer. I just need more information. It's pretty scant information that I have. So I need more information. So she's going to do an investigation. She'll talk to each of you. She'll talk to other people that you mention and suggest. And she will submit a report for the court to review. She'll send copies of that same report to you all. We'll come back at a future time, which we'll set here in just a moment, to discuss whether it'd be appropriate to move forward with the restrictions that Ms. Nilsson is proposing, or if some other type of arrangement would best serve the best interest of the child. So I'm going to just do a quick notation. Bear with me one moment.
Your Honor, may I add something?
You may.
So he was supposed to do a domestic violence evaluation and a substance abuse evaluation. I received the phone call for the substance abuse evaluation after I had went and filed my paperwork. He has not done the domestic violence evaluation.
Right. I don't show any indication that it has been filed with the court. All right. So as far as the appointment of the family court investigator, I'll prepare an order and appoint her, Ms. Jennifer Schaefer, as the family court investigator. Information I have as far as phone numbers, Ms. Nilsson, your phone number ends in 9197.
Yes, Your Honor.
Okay. And Mr. Daly, I'm just checking for your information here, making sure. Let's see, previously Mr. Brungart represented you, and I just want to make sure that I have your updated information here in the case file. The Riverview Drive address, Mr. Daly, is that where you're at?
Yes, Your Honor.
Okay, and then your phone number ends in 2433?
Yes, Your Honor.
Okay, great. So that's good. Then Ms. Schaefer can use that contact information to be in touch with you. Let's take a look at a date to return after she's completed her report. Let's set it out roughly 6 weeks. Today we're the 22nd, or probably the 24th. So that's June 12th. We'll set the matter for June 12th at 9 o'clock in the morning for review of that family court investigator report. And then to take a look also related to the motion for the parenting plan modification. Are both parties, Mr. Daly, are you available on June 12th, Wednesday at 9 a.m.?
Yes, Your Honor.
Okay. Ms. Nilsson, how about you?
Yes, Your Honor, I am available.
Okay. All right. We'll see everybody then on June 12th at 9 a.m. Look forward to the communication from Ms. Jennifer Schaefer.
Your Honor.
Yes, sir.
Would I be able to continue my visitations?
Will you be able to continue your visitation?
Yeah.
I'm not making any adjustments to the current November 2023 order, so it continues to be Wednesday from 5 to 7 and Saturday noon to 4 supervised.
So they can continue starting on this, or starting on Friday, Saturday, I mean?
Yeah, there's been no alteration of that order, so if that should continue.
Okay, it has not continued for a while, and
Okay.
Tasia has not been able to come during visitations, and I just wanted to see if there's a continue.
There's been no change to the court order, so if you feel that the order is not being followed or it's being violated, then your options would be to one, to take court action. You could file a motion for contempt alleging or contending that there's been a contempt, and that we could have a hearing on that. Or you can talk to the other parent and figure something out so there's compliance with that court order.
Okay, yes, Your Honor, and I have filed contempt charges also.
Your Honor, the reason why I stopped visitations was because of him.
So we're not going to discuss the issue at this point. If the court order is the court order, it's expected to be followed. And if any party feels that it's not, then they could bring a motion to address that issue. So we'll see everybody on June 12th.
All right, thank you, Your Honor.
Roy Daly and Shariah Nielsen, 23-3-30408 is the cause number. Ms. McLean, I apologize. I was trying to get all those cases done at once. I apologize.
That's okay.
So you're
I've been working in the background.
Okay, you're representing Mr. Daly and.
I am, Your Honor.
Okay, very good. And is Shariah Nielsen on the line today?
Yes, Your Honor, I am present.
Okay, welcome to you. Do you mind turning on your camera? Appreciate that. Thank you.
No problem.
And then Ms. Looney, are you on the line today? Just wanted to touch base. The state is involved, but not necessary for this. So this is a motion brought by Mr. Daly related to contempt. And and it's related to visitation. And when I looked at the file, I didn't see that there had been service upon Ms. Nielsen.
And I reached out to my client this morning as far as my review as well. I didn't observe that. He indicated that his dad both mailed a copy of the orders and also personally served Ms. Nielsen. I can secure documentation from him and get that filed with the court. Obviously, she's here, so she would have been provided some notice. But I didn't also receive any or see any responsive documentation from her in response to the contempt motion.
Right. Okay. Yeah, let me just briefly touch with Ms. Nielsen. Ms. Nielsen, did you receive information related to the motion for contempt? In other words, did you get a copy of the motion for contempt and supporting documents?
Yes, Your Honor, I did. I got them in the mail.
Okay. And did you file something with the court as far as your input on that issue, or were you relying just upon your voice today?
I have not yet, because I wasn't sure how or like what papers I needed to get to respond back to the motion.
Okay. So there's a couple ways to proceed. Regarding the service issue, I don't have anything on file that shows that you were served with the motion for contempt and supporting documents. And so there's kind of a strict enforcement of that since you haven't been served with that, then we wouldn't move forward. We'd need to get that documentation showing that you had been served, and we'd come back and readdress the issue. That's one way. The other way is that you waive that requirement. In other words, you say, yeah, I wasn't technically served because the affidavit isn't on file that says I was served. And then we move forward today. However, we don't have your written response, and Mr. Daly doesn't see your response either. So my preference is to likely just set it over and have that proof of service filed, and then you'd have opportunity to file something in response, and Mr. Daly would have an opportunity to reply to your response.
Okay.
So Ms. Nilsson, are you comfortable if we were to continue this matter?
I would like to be able to respond back to the motion and have it set over if they're okay with it as well.
Okay, Ms. McLean.
Whatever the court determines, obviously our concern is enforcing the current temporary order on visitation. I guess I would just ask that the court provide a bright line notice to her that that order is still in effect. There's nothing in the temporary order that was entered on November 14th of 2023 that allows her to unilaterally cancel or terminate visitation. And so we would expect that my client's visits would resume tonight at 5 o'clock.
So I'm inclined to set the matter over to May 22nd, which is 2 weeks from today. So that means, Ms. Nilsson, you'd need to get your response in soon, hopefully this week, and then provide a copy to Ms. McLean. And we'd be back on the motion docket on the 22nd of May at 9 a.m. to hear argument. Then okay. I also make note, and I think that's proper to take note of that, on November 14th, 2023, the court ordered a visitation schedule that the father would have visitation from Wednesdays 5 to 7 p.m. and Saturdays from noon to 4 p.m. And I didn't see a particular provision in that parenting plan that allows unilateral withholding of the child. The allegation here is Mr. Daly has not seen the child since the end of February. So can you tell me if the visit that the court ordered tonight is going to happen?
Yes, it will happen. The last court hearing that we had, which was, I believe, on the 24th of April, we had decided to continue visitations from that point on.
Okay. All right. So we'll anticipate that that court order will be followed, and then we'll see everybody on the 22nd. Any final questions?
Yes, I'm sorry, I didn't get in my notes. So when is her response due to me?
Well, I didn't give a specific date. So if we look at the calendar here, today being the 8th, Ms. Nilsson, would you be able to have your submission by this Friday?
I believe so. If not by Friday, then by Tuesday the 14th at the latest.
Okay. Ms. McLean, with that? Okay, let's do that. Let's shoot for that goal at the latest, May 14th, submitted to the court and also copy to Ms. McLean, and then that'll give her an opportunity to respond, and we'll be back here on the 22nd at 9 a.m.
And is I'm not sure if my office has forwarded to Ms. Nielsen yet an email agreement, but we can do that. My preference would be that we serve each other through email if she's agreeable to that.
Any thoughts on that, Ms. Nielsen? Sometimes parties will agree to service by email as opposed to using the U.S. Post Office or personal service. Do you have any thoughts?
Yeah, and email them to her.
Okay. So Ms. McLean, it sounds like she has an agreement you can look over that basically says, hey, the parties are going to use email to exchange documents and serve each other documents. And if you're comfortable with that, you can review it and sign it. If not, there's no obligation to do so.
Thank you.
Okay. Any final questions, Ms. Nielsen?
I don't believe so at this point in time. I would like to state that if any court hearings land on a Tuesday or a Thursday, I have school those days from 9 a.m. to 12 o'clock.
Yeah, we can take that into consideration in the future. If there's any date set for those, you can remind us of that.
Okay, thank you, Your Honor.
All right, very good. Thanks.
Let's take Roy Daly and Soraya Nielsen, if I pronounce that correctly.
It's Sharia, Your Honor.
All right, pardon me.
Your Honor, Noel McLean appearing on behalf of the petitioner Roy Daly.
All right, Mr. McLean, it's your client's motion.
Yes, Your Honor. Thank you very much. So we were here a couple of weeks ago, at which time my client had not provided proof of service. And even though Ms. Nielsen was present, the court set this matter over to today. We did file on May 9th the proof of the personal service as well as mailed service on Ms. Nielsen. That took place on April 27th. And as I indicated, she was present 2 weeks ago. The temporary order that was entered back on November 14th of 2023 allows for supervised visitation at paragraph 14. There is no provision in there that allows Ms. Nielsen or the supervisor to unilaterally terminate visitation. But Ms. Nielsen took it upon herself to terminate my client's visitation commencing February 23rd. And she did not allow visits until the parties were back in court on April 24th. That's when visits did resume. Coincidentally, when she denied visits on February 23rd, 4 days later, she filed a notice of intent to relocate, although that had not been properly served on my client. So I would suggest that that does suggest that there's some ulterior motives here. Ms. Nielsen acknowledges in her declaration that she unilaterally denied visitation. There is no evidence that Mr. Daly was under the influence. There's no evidence from the supervisor about any issues at the visitation that was terminated by Ms. Nielsen. I've reached out to Ms. Hargrave, but unfortunately she's not returned my calls at this point. Visits have now been supervised for 6 months with no expansion. My client has complied with the substance abuse evaluation. Those records were filed with the court, and that was a collateralized evaluation. There was no recommendation for treatment and no significant issues found as it relates to Mr. Daly. So at this point, his visits are currently every Wednesday for 2 hours supervised and every Saturday for 4 hours supervised. When Ms. Nielsen unilaterally terminated visitation, that resulted in my client missing 9 Saturdays or 36 hours and 8 Wednesdays or 16 hours. So we're asking that the court allow for makeup visitation of 52 hours. We're asking for the expansion on Saturdays, that those visits extend to 8 hours from 10 a.m. to 6 p.m. for the next 13 weeks. Quite frankly, since there's been 6 months of supervised visitation, really, I think that this matter needs to proceed to unsupervised visitation because that's a lot of responsibility and time for a supervisor. And again, there's been no information to suggest that any of the visits have been inappropriate. So we're asking that the court enter a finding of contempt, award the makeup visitation. We're also asking for the court to order $300 in sanctions and $750 in attorney's fees. I have provided a proposed contempt hearing order for the court.
Ms. Nielsen, is there anything you wish to say?
Yes. In the parenting plan that I went and filed after I stopped visitations, it does show 2 sets of photos with Roy and Paisley. In one set of photos, it shows
I
that
guess
he is
I guess I
high.
would
And
object.
then,
I would object at this point because one, this is outside the scope of her reply declaration. And I'm not aware of any references relative to photos or what those may show.
Okay, well, I'll allow her a little bit of freedom at this point. Go ahead, ma'am.
in one set of photos, it shows that he is high, and then the other set of photos, it shows that he is high and had some alcohol in his system. I did stop the visitations due to the incident back in March of 2023, when he had been under the influence as well and brought out a gun with my daughter present in my arms. I felt that he had been putting her life at risk showing up to visitations like that. Now, the last visitation that he had back in February of this year, I had to go and drop off her diaper bag because the supervisor forgot her diaper bag at my house. And upon dropping it off, his eyes, I noticed, were pink. And usually when they're pink, he is under the influence. Now, I was with him for 7 years, so seeing his demeanor and the facial expressions he has when he is under the influence, you catch on to those really well. So I felt that I needed to stop visitation so that her life wasn't being put at risk. Now, when we had court on the 24th and the judge said to resume visitations until further notice, I did go back and continue visitations from that point on. I have been speaking with the investigator on everything and speaking with the supervisor, Tara, and in communication,
We are not objectives to
Tara
any
has,
hearsay. And again, there's no declarations from the supervisor here.
I
yes,
understand
I have,
that, and we're getting well beyond the issue of the contempt right now, so let's focus on that. Ms. Nielsen, anything else you want to say?
I've been speaking with the supervisor the last few days as it is, and have asked her to write a declaration involving the visitations.
All right, here's where we're at. This is a real short, simple, easy issue. You may have had some concern about Mr. Daly's appearance. You're not entitled to, on your own, decide you're not going to follow the court-ordered parenting plan. If you think it needs to be changed, you file a motion asking to do that. But you don't decide yourself whether or not you're going to follow the parenting plan. That's real simple. Do you understand that?
Yes, Your Honor, that was my misunderstanding.
I am going to find contempt. That's very clear. The civil penalty of $300 is appropriate.
Your Honor, I am on TANF and going to school currently. I'm limited on what they provide me with every month.
Well, that's my concern. All right, I'm not going to order fees. I am going to order the civil penalty. The visits currently are 2 hours. Is that right?
2 hours on Wednesdays and 4, although those days fluctuate depending upon agreements between the supervisor and my client. And then 4 hours on Saturdays.
All right. Moving forward, the Saturday visits are going to change to 6 hours by way of an attempt at makeup visits. I don't want to put any more burden than I have to on the supervisor. And
so currently the hours I think are noon to, I think it's noon to 4, so noon to 6.
Ms. Nielsen, do you have any idea of the supervisor's schedule?
She during the week, the reason why they're 2 hours on Wednesday is because she gets off at, I believe, 5.
Okay, what about Saturdays? Do you have any idea what her schedule is?
Saturdays, from what I understand, are open for the most part. She does help her daughter out with feeding horses in the morning and at night.
Okay, let's go noon to 6.
And then I have a question, Your Honor. After those hours are made up, do they go back to noon to 4?
Well, there's an awful lot of other issues going on in this case right now. I suspect that things will change before we get to that point. Excuse me. However, yes, that's so adding 2 hours, that's what, 26 visits? So I'm indicating Saturday visits.
This is at paragraph 9 in the contempt order. So 12
Leave it
noon.
at, yeah, I'm changing it to noon to 6 p.m.
And then instead of saying through 8/17, just provide for 26 visits.
Yes.
And then will you strike at paragraph 8 the lawyer fee?
Yes, ma'am.
And then at paragraph 1 also the lawyer fee.
Yes.
Is the court willing to reserve those?
Not at this point.
Okay.
You can see where we stand in the balance of the litigation.
And then at paragraph 11A2, would you strike the attorney fee? The language of the attorney fee?
Yes,
And
I'm
then
just
I will,
and attorney's fees will leave the sanction.
okay. And then I'll provide Ms. Nielsen with a conformed copy by email. The last time we were before Judge Evans, I was asked to provide Ms. Nielsen with an email agreement so that we could serve each other by email. I've not yet received signatures from her on that, so I need her to cooperate in
Yes,
signing
I
it.
had a question for you on that.
Why don't you reach out to me by phone rather than here through court?
Okay, I wasn't sure if I was supposed to
Call
sign
Ms.
it.
McLean's office and you can discuss what your concerns are.
Thank you.
That'll be all.
Next, I have Roy Daly and Shariah Nilsson, 233304-08. There we have Ms. McLean present representing Mr. Daly. And Ms. Shariah Nilsson, are you on the line today?
Yes, Your Honor, I am.
Okay, great, welcome. And we have, is Ms. Schaefer on the line today? Jennifer Schaefer?
Yes, I'm here, Your Honor.
Okay, very good, great. All right, let me just pull up my notes, just one moment. All right, this is Mr. Daly's motion related to his motion to prevent relocation. And
That's correct, Your Honor.
so I've read all the pleadings related to that have been submitted. So I'll hear from Ms. McLean first and then from, Ms. Nilsson thereafter.
And the only comment that I would have as it relates to testimony or argument from Ms. Nielsen is that I have received absolutely no responsive documentation from Ms. Nielsen. Ms. Nielsen was personally served on May 20th. Obviously, more than 20 days have passed since she was served, and the docket notice clearly identifies that her responses were due on May 28th. Clearly, as you can see, she's had no difficulties filing responsive documentation in this case. So I'm concerned about her potentially bringing up issues that are not included in her notice of intended relocation that my client hasn't had an opportunity to respond to. We are asking the court to restrain the relocation of 2-year-old Paisley. It is accurate that she emailed that notice of relocation directly to him. Apparently, there was some colloquy in open court about that. Technically, I think even as a party, she would have an obligation to have a third party do that in order to provide for appropriate service. My client had continued to comply with third-party service to make sure that there was an independent witness. So I would just raise that technicality. My client provides as attachment A to his declaration the documentation that he had prepared as far as his objection. If you review through those attachments, you'll note that most of those documents were dated, I think it was April 7th. He actually had an appointment with me. That was our very first initial consultation on April 17th. I reviewed through that documentation with him. I provided him with additional documents, which included the notice for hearing, the declaration, and a proposed temporary order. And when you look at all of those documents, you'll note that those were dated for April 17th, because that was consistent with when he met with me and we went through those. He had also prepared, and I had reviewed his contempt documentation, and you'll note that his contempt motion was filed on April 18th, but when he attempted to file his objection to the relocation, the clerk's office denied his filing and said that it was not a legitimate filing. There was no basis for him to file that. So he's been substantially prejudiced after having met with me and gone through the documentation that he needed to file. I don't know if the clerk's office didn't see the relocation that had been filed by Ms. Nielsen back on February 27th. I guess procedurally, my concern is as a practitioner, obviously, if I'm having documentation that's rejected, there should be some notice that's provided so that an individual, particularly a pro se, has the ability to come back to court and say, look, I attempted this. This is what I attempted. And this is what I received from the clerk's office denying my filing. But he's here before the court because he attempted to timely file and that was rejected. So he has been substantially prejudiced as far as timeframes and information goes. We are asking the court to restrain the relocation. If you go back and look at Ms. Nielsen's notice of intent to relocate, she provides her reasons at paragraph 3 to have more stability and to better my daughter and I's life. I have a job lined up and a place to stay. There has been absolutely no information or documentation relative to a job that she has lined up, or what, and she identifies an address on where she wants to stay. The cost of living in Caldwell, Idaho is at least double, if not more, on housing alone. And we provided that information attached to Mr. Daly's declaration as it relates to the address that she's identified. And the cost for rent for that location alone is $2,050 a month. So again, it's concerning as it relates to the good faith basis for this, again, because we have no idea as far as whatever job she anticipates she has or has been offered.
Can I ask you a question, Ms. McLean?
Sure.
In Ms. Schaefer's report, there was discussion of Idaho and there's also discussion of Renton. Did you receive any notice regarding potential move to Renton?
Did receive no notice involving Renton. And I would also note that Ms. Schaefer's discussion about relocation exceeds the scope of your order as far as her appointment. If you go back to her report, even on page 2, or on page 1, it identifies that her report was to investigate issues related to making a parenting plan for this child, abandonment or neglect, domestic violence, substance abuse, and any other issues discovered that could affect the safety of the child. She was not charged with investigating relocation. There's obviously, 9 factors that need to be involved. I don't see any discussion about those factors. My client was not asked about those factors. So the suggestion about school, obviously not identified in the notice of intent to relocate. Renton, not included in the notice of intent to relocate. And there needs to be a full investigation relative to relocation and the 9 factors that are involved. My client needs to have an opportunity to weigh in and to produce his evidence relative to those issues. So the one line about being able to relocate to Renton, I don't even know at this juncture what schooling she's supposedly taking that's 2 days a week, what this intended program is that she wants to get into. There's a vet tech program down at Portland Community College. That's 45 minutes, an hour away compared to going up to Renton. And again, the cost of living, when she could maintain her cost or she could maintain her home here and commute back and forth to school. There's also online availability for vet tech programs. So those are issues that have not been ferreted out. My client, again, was not asked one question by Ms. Schaefer about relocation because that wasn't part of her duties as far as the guardian ad litem appointment order for her. When you look at where we're at as far as this current case, obviously my client has visitation with the child. His position is that he has a bonded relationship with the child and that was unilaterally interrupted by Ms. Nielsen. Interestingly, 4 days after she filed her notice of intent to relocate is when she started to deny my client's visitation for a protracted period of time in violation of the court order, and she was subsequently found in contempt for that. Our position is that we do not believe that there is a likelihood that the relocation will be approved once there is an investigation and both parties have had an opportunity to weigh in on all of the factors of relocation. My client has his bonded relationship. Historically, my client's family has had, extended family who lives locally has had a bonded relationship with the child. The paternal grandmother provided work-related daycare for these parents when they were together here locally. There clearly is no agreement between the party. This is a young child. She's 2 years old. It's crucial time, and the statute talks about having consistent contact and maintaining relationships with both parents. That's in the best interest of the child. That's the overriding concern here. Our position is that it would be more detrimental to move the child from bonded local relationships to an unknown location that is much more expensive with no extended family in either of those areas. We're currently operating under a temporary order, so there have been no 191 findings in this case. There has been no proof of any efforts by mom to obtain employment locally, to provide other educational opportunities locally that would again place a priority on maintaining this child's relationship with her father. My client is full-time employed with an employer where he's been for the last 8 years. He's stable in his housing, and he wants to have a bonded and maintain his bonded relationship with the child. So we're asking that the court restrain the relocation, and we've also asked that the court consider an award of attorney's fees.
Thank you, Ms. McLean. Ms. Nelson?
Yes, I do have family that live in Idaho. My sister, who is a year younger than me.
I guess again,
I'm speaking. I'm sorry, but I am
So
speaking.
Ms. Nelson, sometimes there's objections made when another party's making an argument, and so when objection is made, I need to hear what the objection is and then rule on that. So just pardon me while I hear that objection. Ms. McLean.
So, again, I'm objecting to Ms. Nielsen providing input to this hearing when she has an obligation to provide written declarations to the court so that this is not supposed to be by surprise. And again, she's historically filed documentation. She knows how to do that, and the docket notice was clear. So I would object to the court considering any verbal input from her in regards to this motion that has been properly filed and served.
Let me touch base with you, Ms. Nielsen. Ms. Nielsen, did you file any declarations or any information supportive of your different positions, the things you're talking about today?
I'm in the process of trying to get my sister to fill out a declaration and send it to me. She works a full-time job, and my brother-in-law is a truck driver in Idaho. So they have a full schedule. I have asked them to fill out a declaration and send it to me. So I am in the process of getting that. My brother-in-law is the one who is helping me since I'm not in Idaho. He is in also has spoken to a couple jobs out there, and I am in the process of getting declarations from those as well.
Okay, so those are in process as far as any declarations that you yourself have submitted.
When I filed back in February, I was unsure that I had to submit those evidence. Otherwise I would have had gotten those a lot sooner. The schooling program that I'm wanting to do isn't the first time that I have been in the process of trying to get done. I'm wanting to be a veterinarian, and it is not the first time that I have been trying to go to school for it. Now that my daughter is older and is able to be in Head Start, there are quite a few different Head Starts near where I live and near the job opportunities that I have in Idaho. There's also one not far from
Again,
I'm
object because this is exceeding the scope of the court's question.
Yeah, and then any other declarations or from yourself or from others related to kind of a factual basis that I could read and know about, and then Mr. Daly could read and know about?
I don't have them at the moment, but I can get them to the courts.
Okay. Okay. All right. So I think I'm going to sustain the objection. And the reason I'm doing that, Ms. Nilsson, is that the way this process works is that it's really document driven, it's paper driven, where a person will write out their reasons, their rationale, their support for their particular position. That allows me to read and digest it, and allows the other party to read and digest and then respond to that. And then you would have an opportunity to reply to their response to find any shortcomings or things that they overlooked or placed undue emphasis. So I don't have any real documentation from you that lays out your position. I know that you spoke with Ms. Schaefer and you provided her some information, and I reviewed that report. But at this point, there's just the rules just aren't there. There's not a factual basis that's been put in print on paper and shared with the court. So I'll give you 3 minutes to share your view, and then we'll hear from Ms. Schaefer. So go ahead and tell me your 3 minutes of your rationale, and I'll just leave it at that.
So basically my thought process on everything and where I stand. Is that what you're?
Sure. You're just basically your motivations and reasons for wanting to move.
In Caldwell, Idaho, the veterinarian program that they have specifically that I'm interested in going into is a large animal vet program. It is from what I understand, a 4-year program. They have that specific one due to being I want to say a country, where there's more farming properties out there, more large animal opportunities. Like I said, it is not the first time that I have tried to go to school. When I first attempted to go to school was in 2020. Before I came back from Texas, I was trying to go to Texas A&M to become a large animal vet. I had moved down there and lived with my cousin for a few months, and that was also when COVID was going on, so I was unable to get into the college. I am a hands-on learner. I don't do good at doing things online and not being in the room learning from a full-on professor or teacher. Doing my research, being a large animal vet, does have its benefits. It's got good dental benefits, good insurance. If my daughter has to have surgery, they not saying she does, but if at any point in time has to have surgery on some sort of body part, I'd be able to afford it. So that's why I was looking into Caldwell University out there. My sister, the house that is in Roy's declaration, she is actually mortgaging that house. They pay $1,500 a month. The job or jobs that I have lined up out there, one is at a feed store, and the other one is actually with his friend's wife at a veterinary clinic. So I'd be able to work those jobs when I am not at school and while Paisley would be in Head Start. As of here, Renton is another college that I was looking into going as a second option. That is why that one is not listed, because my main focus was in Caldwell. And I had talked to Ms. Schaefer about Renton as a second option because it is 2 hours away. It is actually one of the cheapest places to live here in Washington. I have done my research on that as well. Now I have a cousin who actually lives in Seattle. He is a full-time worker. I can also get in contact with him and see about him putting in a declaration as well. As far as living in Renton, that won't be a problem with visitations, as I can drive down here from Renton and be a lot closer. And he can still have his week visits and his weekend visits with Paisley if they are still granted. That for Renton, that was my second option. Hence, like I said, why I didn't put it in my declarations. Caldwell was my main source of relocation as far as the large animal veterinary clinic goes.
Thank you, Ms. Nelson. Turn the time to Ms. Schaefer if you have any comments, Ms. Schaefer.
Yes, I do. I did speak to Mr. Daly about all of this, and his concern was that she was making the move more to get away from him and to separate the father-daughter relationship. As I stated in my report, I do have concerns with the consideration of Idaho. The 7-hour drive one way for the child is not in the best interest of the child. Mom did state that she had other options to look at different schools. And she is also applying for scholarships, I believe, through TANF. And so that's why we were considering that she would need to have some sort of answer by the court so that she could either accept those scholarships and put them into place for further schooling. I felt the child's age, even though she is 2 and we'd need those close contacts with both parents, it would also not interrupt any schooling for the child per se. If we waited 3 or 4 or 5 years for her to be able to pursue this college education in a more further away location, then we would be uprooting a child who's already started a schooling age and already started an education program. Whereas I felt like Ms. Nielsen might have the opportunity to finish the program before having to disrupt the child's education. So I did put weight into that as well.
All right. Thank you, Ms. Schaefer. Ms. McLean?
Of course, much of what Ms. Schaefer just testified about is not included in her report. I don't see anything in her report, and in my discussion with my client, the factors that are outlined in the statute were not discussed. Again, that's not something that this court tasked her with. Otherwise, we would have provided additional information to her relative to those issues. The cost of living, at least from what I can get online for Renton, is 23% higher than the national average compared to Kelso, which is lower than the national average. There are online programs for this veterinarian associate's degree that she's talking about. There are, again, it's my understanding that there's one available at Portland Community College. There are a lot of moving parts, and clearly my client is entitled to have an opportunity to respond to all of the information clearly that was not included in her notice of intent to relocate. I have no information relative to the schooling that she's currently doing, how far she is in that schooling, what her grades have been. I have no financial aid applications. If she moves out of the state, that's going to disrupt her. I understood that she's receiving TANF as well as state medical for the child, so that would be disrupted. There's just too many parts, and she's again come here empty-handed without providing information for us to be able to make determinations. So I think the fallback is that we maintain the status quo, maintain the relationship and the bond with the father, and allow this to be fully investigated by a guardian ad litem.
All right, thank you. All right, so we start off any request to relocate with a presumption to the primary custodial parent. The presumption is that the move is allowed. So Ms. Nilsson, under this temporary plan, is technically the primary custodial parent, with Mr. Daly having visitation on the weekends. So, the thing that really strikes me about this case is that there's a lack of information, a lack of hearing from Ms. Nilsson's viewpoint as far as, I heard her plan today, and I also read about her plan a little bit from Ms. Schaefer's report, but there's lots of gaps, there's lots of holes. There's 9 factors that were mentioned earlier that need to be reviewed and considered by the court, such as the child's relationship with parents, siblings, other important people, agreements between the parties regarding children, disruption of the child's contact with the mother versus disrupting the contact with the father, if there's any limitations under the parenting plan, her mother's reasons for the move, if they're good faith or bad faith efforts or reasons, and the father's reasons for objecting to the move, whether that's good faith or bad faith, the impact on the child, allowing or preventing the relocation, the quality of life, resources and opportunities in the current location and any proposed location, other arrangements to foster and continue a relationship with the child if the move was to be allowed, and alternatives to Idaho, whether Mr. Daly could move to Idaho, and then also financial impact of moving or not moving. I don't have a lot of information related to those 9 factors. I have information from Mr. Daly that shares his point of view. I have even less information regarding Renton. That was in no pleading that I saw from Ms. Nilsson, and there's lots of information related to that's just not there. So I think the presumption has been overcome, and I'll sustain the prevention of the relocation at this point. So certainly there's procedurally there are some concerns related to the pleadings, maybe on both sides, but at this point there's just not enough information for me to allow that. So I think the motion is well taken, and the relocation is prevented at this point.
Okay. I have a question, Your Honor. When I get all of the information to back up my claim, can we come back to the relocation hearing?
Yes.
Okay.
You'd have to basically start over again, providing notice, and then following the procedure and providing documentary proof for your declarations and the like.
Okay.
All right. So
sorry.
Go ahead, Ms. McLean.
Is the court going to reserve fees?
Oh, I didn't quite hear everything you said.
I'm sorry. Is the court going to reserve fees?
As far as attorney fees, at this point, I'm going to deny attorney fees. If there's another showing of lack of follow through and declarations, then that certainly would be a strong reason for imposing fees. But at this point, I'll deny any additional fees.
I have provided the court with a temporary order about moving, as well as a temporary parenting plan.
They have that. And Ms. Nilsson, did you receive a copy of that order, the temporary order about moving with the children, the relocation?
I believe so. Let me see here. There was a lot going on in the packet that I received. It just kind of seemed all over the place. Let me see here.
She would have received a proposed orders packet that has the temporary order restraining the relocation and a proposed temporary parenting.
Okay, it looks like I did get the new parenting plan that he had filed.
I'm specifically looking at the relocation orders. It's a temporary order about moving with children, parentheses, relocation.
Mhm.
So what I want to know is, since that's a proposed order based on today's ruling, do you have any objections or concerns with that order?
In the parenting plan, he's asking for joint custody. I'm still
not talking about parenting plan. I specifically, I'm looking at this document. If you can see that on the Zoom.
It's hard to read it. Temporary order about moving with children.
While she's looking for that, the court will need to make a change at paragraph 5I, as that related to the fees.
Thank you. On that 5I, I'm simply striking the phrase reserved for further ruling. I struck that and wrote denied.
All right.
Ms. Nelson, did you locate that order?
I'm still looking at it. I found it.
Okay. So the paragraph 1 says the court considered a motion for temporary order preventing move with children. And then it talks about the court finds that the child has not moved yet, talks about the circumstances that don't justify allowing the move before a final decision. And then it goes down to specific findings. And if you look under 5I, that's where I mentioned that I struck the wording reserved for further ruling and wrote in the word denied. And other than that, I don't see any need to change any of the other findings at this point. And if you have any strong concerns or objections with any of that language, please let me know.
Okay. I would like to say, in 5A, as far as from my understanding, Paisley has not seen his side of the family, in quite some time. So I don't understand how she would have a bonded relationship with his side of the family. With him, yes, I would like there to be a bond, but when we
So
lived
we're gonna
together,
focus specifically on the order. If you have any specific objection to any language in this proposed order that we're reviewing, that's kind of the focus of our attention right now. So that's what I'm looking for feedback from you if you have any specific concerns with the language in this proposed order.
I mean, I would like to be able to move and do the proper schooling, and have a better future for Paisley and I will get those documentary filings to you, and if we can come back to this hearing when those are filed, that would be great.
Okay, so I've gone ahead and I'm going to sign off on the temporary order about moving with children with relocation. So there needs to be a trial on the issue. And so there'll be, if you're interested in that, you'll need to put those wills in motion. You can check on washingtonlawhelp.org for additional information on how to make that happen. But otherwise, I've signed off on that temporary order preventing the relocation at this point.
Your Honor.
Mhm.
Paragraph 6 has you adopting the temporary parenting plan.
Yeah, and I'm not prepared to rule on the temporary parenting plan.
So are you going to cross that off and just indicate reserved?
Yeah, I will. Let's just say that the court reserves ruling.
On a temporary parenting plan until trial? Or on a temporary parenting plan?
Yeah, on a temporary parenting plan, and I'll strike until the trial.
Okay, thank you very much. I'll provide conformed copies to Ms. Nielsen and Ms. Schaefer once they're available, and Ms. Looney once they're available on Zoom. Or I'm sorry, on Odyssey.
Okay.
Thank you.
All right, that'll conclude the hearing today. Thank you.
No problem. Nielsen and Daly.
Yes, I'm appearing on behalf of the petitioner, Roy Daly.
And do we have Miss Nielsen? Ryan Nielsen?
I don't see her. We were in court yesterday and referenced today's hearing.
I don't see her name anywhere. Miss McLean, where do we stand?
So this is on for the review of the guardian ad litem report that was filed on June 7th.
Yes, ma'am.
So I guess from
We've
our
got a pending contempt motion.
the contempt has already been heard. Ms. Nielsen was found in contempt. Your Honor actually heard that motion and,
I see that.
and ordered extended visits. He now has 6-hour visits every Saturday that are supervised to make up for the 52 hours of visitation that he was denied. We were before Judge Evans yesterday on our motion to restrain relocation. That was granted. The court did not enter a parenting plan at that time because we were scheduled for today's guardian ad litem review. I have reviewed through Ms. Schaefer's guardian ad litem report, and then she had also requested a hair follicle and UA from my client, which we submitted. Those were filed yesterday. Those do show positive for my client for cocaine and marijuana, negative for alcohol. And we also filed the domestic violence evaluation from Ms. Lovely that recommended 12 months of, I think it's the intervention program. I do have comments and concerns relative to all of those issues.
Okay, just a second. The baby is cute as can be, but if you can take him out, please. Thank you. All right, Ms. Schaefer,
Yes, Your Honor.
anything you want to comment on?
The things that Ms. McLean listed came in after for the majority part of my submission of my report, so I wasn't able to take those into consideration with my recommendations. I also held off on making recommendations for supervised visits until these reports came in. The only additional concern that I would like to state is that the supervised visit person who was a family friend really wasn't documenting anything of dates and concerns. And so a lot of that is a concern for me moving forward if that person was to continue with supervised visits.
And Ms. McLean, your filings from Monday haven't made it in yet, so this is the first I'm hearing about it.
Okay. And I apologize for that. I had asked Ms. Lovely, I'd received Ms. Lovely's report, I think it was on Friday. I had sent her an email because there was some misinformation in her report. Her report had identified that there was no collateral input that was received by the prior substance abuse evaluation. My client had filed that substance abuse evaluation back on April 17th under seal. The report directly indicates that they did speak with Ms. Nielsen and did receive her collateral input. So in my email to Ms. Lovely's office, the reply was that they did not have UA results, or it wasn't referenced whether or not there had been a UA that had been submitted at the time of that prior evaluation. And so that's why there was a recommendation for Mr. Daly to complete an additional substance abuse evaluation. Obviously, in light of the recent drug results, I anticipate that the court would require him to do another substance abuse evaluation, again with collateral input. I've referred him to Awakenings and to the Cowlitz Indian tribe. I know that Awakenings will perform collateralized evaluations. I think typically they charge $200. I don't know as far as their availability or when they'll get that evaluation back, but I've provided him with that information and expect that the court would order him to do that. In regards to supervised visitation, I share much of Ms. Schaefer's frustrations with this supervisor. I attempted 3 times, left 3 phone messages to Ms. Hargrave. She never once returned my call. I have no documentation. My client has no documentation. Everything that my client had heard from Ms. Hargrave was that his visits were positive. And even Ms. Schaefer notes that in her discussion with the supervisor, that the supervisor commented that that he was always polite, he was always timely, he knew when his visits were, that they were positive visits. These peripheral suggestions that, you know, she wasn't close enough or she may have smelled alcohol one time, one would have assumed, given that Ms. Hargrave has been in a family legal assistant for 25 years, that she would have reached out to Ms. Schaefer, and clearly she knew how to reach out to Ms. Schaefer, or that she would have reached out to Ms. Nielsen. So the reliability of those claims when we have no information in real time is concerning.
Do we have any kind of an alternative for a supervisor?
So my suggestion would be, and I will tell the court that my calendar's been a little harried. I did talk to my client briefly last night. I forgot to inquire, and I know that he's here today. I guess my recommendation would be, because these are 6-hour visits, if the court's going to continue with supervised visits every Saturday. My client's mother previously provided daycare for the child when the parties were together. The court has now adopted lay supervision rules. I'm not sure why those weren't adopted when the temporary order was entered last November. And it could have been that my client's former counsel was out of county and wasn't aware that we've adopted supervision rules. Those supervision rules, I believe, also require, at least my version of them, require that the supervisor is to provide notes to all parties and guardian ad litems following the supervised visitation as far as notating any concerns or issues. So my suggestion would be that my client's mother be the supervisor, that she be required to sign the supervision requirements. My only question for my client, Mr. Daly, is 1, whether or not his mom would be available to do that, and 2, if she's electronically inclined where she could provide those notes to everybody by email.
Okay, well, let's do it this way. Step 1, Mr. Daly, we're going to maintain the Saturday supervised visits. Those don't happen until Mr. Daly submits a clean UA. So he's got a few days between now and Saturday to do that. With Ms. Nielsen not here for whatever reason, I am concerned that if I change the supervisor right now, it's going to lead to some chaos. So what we'll do is we'll maintain the current supervisor even with the deficits right now. We'll put the matter over 2 weeks to review who the supervisor will be. So how far out do I have to go to get to one that's not? All right, July 3rd at 9 o'clock to review who the supervisor will be. If we're still having the same problems with the current supervisor, then we should make that change. And that covers everything.
Is the court willing to order that the current supervisor is required to submit visitation review notes to everybody by email?
She's to comply with the current supervisor rules as established by the court, including that.
Okay, so I'll get those shipped out to, I guess I'll ship them out to Ms. Schaefer, and perhaps she can forward them to her because she won't respond to me. I don't have an email for her. So.
All right, Ms. Schaefer, any problem with that?
No, I can assist in that. Yes.
All right.
Okay, I appreciate that.
And then July 3rd, 9 o'clock.
Thank you very much, Your Honor.
Thank you.
23, Roy Daly and Shariah Nielsen, 23-3-30408 is the next matter, please.
Your Honor, no one will plaintiff hearing on behalf of the petitioner, Roy Daly, and I believe Mr. Daly is also present.
All right, very good, thank you. And Ms. Shariah Nielsen, are you on the line?
Yes, I am.
Okay, I see that Ms. Schaefer, family court investigator, is also present. And Mr. Daly, just if you can confirm your presence just by saying, I'm here, or good morning.
I'm here, Your Honor.
Okay, great, thanks. All right, we were here last on June 12th regarding the supervisor, and we're looking for some updated information related to that, and any domestic violence, or pardon me, yeah, any evaluations related to UAs or SUD.
So I can update the court as to all of those things. At our last hearing in front of Judge Warning, he sent this over to talk about potentially changing the supervisor, as both Ms. Schaefer and my client had expressed concerns about the existing supervisor. We did submit a declaration from my client on June 25th that included a signed supervision oath by his stepmother, Courtney Daly, who has reviewed through the terms of the court supervision order. The only difference in the supervision oath that is submitted is that at paragraph 13 under other, I've provided that the supervisor needs to produce within 5 days of each visit, visitation notes to all parties and their attorneys that talks about the excuse me, the dates and times and locations of the visits, the supervised parents' parenting strengths and or weaknesses, and overall nature of the visits between the supervised parent and the child. Otherwise, my order mirrors the court's pattern form order that has been, or pattern form oath that's been adopted by Cowlitz County Superior Court.
Do you have any concerns about that? The recommendation from their end is as far as a different supervisor, since there was concerns related to Ms. Hargrave, that person being the stepmother, Ms. Courtney Daly. Do you have any input on that?
I personally would like it to be a professional supervisor and not a family member.
Ms. Hargrave, was she a professional supervisor?
She used to work for the courts as a paralegal.
Okay, okay.
Which is why I recommended her.
Okay, okay. Any other concerns if Ms. Courtney Daly would serve as that, in addition to the being family?
I just think that with it being a family member, there are, I guess, ways that she can alter the visitations and not fully write down information that is needed especially when he shows up under the influence. It is, I feel like, a conflict of interest with her being a family member.
Okay. Ms. McLean?
So I would note that right now, under the existing supervisor, not only will she not return my calls, of which I've left her 3 messages, but she's provided absolutely no notes or feedback. She had inconsistent dates. I've provided information to Ms. Schaefer that was not supported as far as her requirement to terminate a visitation if there was a concern that he was in fact intoxicated, which my client denies. And the actual oath itself would require Ms. Daly, Courtney Daly, to terminate the visitation if there were any of those concerns. So at this point, Ms. Nielsen has not provided another proposed supervisor. Ms. Hargrave was not a professional supervisor. My client was not required to pay for professional supervision. And I think that we need to move forward with Ms. Daly providing that supervision.
Thanks. Ms. Nelson, do you have any suggestions of who that person could be as far as supervisor?
At this point in time, I have been trying to find a professional supervisor, but I don't know of any right now. I know I had talked to Ms. Schaefer about professional supervisors, and like I said, I've done research and I'm unable to find one at this point in time, but I do not condone Courtney as a supervisor because of her being family.
Okay. All right, thank you. Ms. Schaefer, do you have any input?
Your Honor, I did speak to Ms. Nielsen about other options. I did give her an option of here in town, but she chose that professional to not be adequate at this time. And she was looking into other supervisors. I do share her concern with it being a family member of his, because it does mean that that person could allow him, and maybe if there was some sort of parameter set up of what that person should be looking for to determine if he's under the influence, that might make Ms. Nielsen feel a little bit better if it was to move forward with that family member.
Thank you. All right, so the supervisor that was previously functioning wasn't necessarily functioning as expected and hoped for. So there needs to be a different supervisor that, obviously the safety of the child is of utmost concern. And there's, from hearing from Ms. Nielsen, the concern isn't so much that as far as safety, but more of kind of just shading things or maybe leaning more towards Mr. Daly and viewing things in maybe a favorable light to him, but not necessarily an indication that there is safety or ability to keep the Paisley safe would be compromised. There's also the issue that if the oath of visit supervisor is violated, then that person could be replaced. So without hearing a viable alternative and the need for that supervisor to be in place, I'll approve Courtney Daly at this point in time, well, recognizing there may be some inherent limitations as far as potential, seeing things through a particular color of glasses. But I think that the base value of that supervisor's position is providing safety, and I think that will be provided.
All right. In regards to answering the court's other questions, we did file on June 20th the negative UA results. My client on Monday completed the second session of the evaluation for substance use with the tribe on Monday, including a UA. He's still waiting for their actual evaluation, but they've scheduled him to start whatever their treatment recommendation is on Thursday this next week. In regards to domestic violence, we have filed under seal the evaluation from Ms. Lovely, from Sam Case, who's with Ms. Lovely's office. That was filed on June 11 of 2024. Mr. Daly, and we communicated with Mr. Case that Mr. Daly wanted an opportunity to see if the tribe could provide those services for him that were recommended at minimal or reduced cost compared to what was being identified as far as the cost from Olivia Lovely's facility. The tribe apparently does not provide that service. So he's reached back out to Mr. Case. And as you heard earlier on this docket, Mr. Case is on vacation until this next week. So the anticipation is that my client would be in contact this next week to get on the schedule to start that treatment.
Thank you.
You're
Ms.
welcome.
Nelson, anything related to that?
Yes, as far as the UA that he recently just did, from my understanding, when he did the hair follicle test, he tested positive for cocaine and THC. Now, from my knowledge, cocaine stays in your system for 90 days and THC stays in your system for at least a month. There are ways you can alter a UA. So for him to test negative a week later on a UA just doesn't set right with me. I would personally like him to do another hair follicle test and go based off of that.
What was the date of the first hair follicle test you mentioned?
The first hair follicle test was June 4th, and so it wouldn't be viable for another hair follicle test for 90 days.
And were those results submitted to the court?
Yes, those were filed on June 11th. And Judge Warning reviewed those and ordered that Mr. Daly was to produce a clean UA. Again, because knowing that once you've had a hair follicle, you have to wait 90 days until there would be another valid hair follicle because the results would be the same. And so he ordered the UA, and once the UA was submitted, then visitation would resume. That was filed on June 20th, and visitation has resumed. The supervised visitation.
Ms. Schaefer, do you have any input?
Your Honor, no, sorry.
Okay, all right, thanks.
Your Honor, I would like to say something. From Ms. Schaefer's report, Roy had told her that he doesn't do cocaine and has never done cocaine. And then when he did the hair follicle test, he tested positive for cocaine. And that was one of my concerns of Paisley's well-being during the visitations, was him showing up under the influence and putting her at risk.
Understood. So back on June 12th of the last hearing, the court indicated that if there's a clean UA result, then the supervised visitations could resume, and that there was a clean UA. And I recognize there are some limitations to UAs, but I think that burden's been met, and so the supervised visitations can resume.
Is there any way that he can do another hair follicle when time is due?
You can certainly bring a motion. You know, it's 90 days roughly is kind of the time frame that hair follicles are viable. So I won't make a prospective ruling on that. You know, if a party files a motion, we'll certainly take a look at it. I think those are the items that were addressed and needed to be addressed today. Any further items, either Ms. Nilsson, Ms. Schaefer, or Ms. McLean?
The only other thing that I would note that in my client's declaration, he indicated that he has no objection to an order that restrains his use of alcohol substances prior to or during his residential time, and that he is following through with the treatment recommendations. And once we get the evaluation, just like I did with the domestic violence evaluation, I'll get that filed and circulated to all the parties. And then the only other question I would have for the court is, are you tasking me to prepare an order? And if we need to schedule a follow-up, or is Your Honor entering a handwritten order?
Yeah, handwritten order, I think, is what we'll do here today.
Okay.
So the handwritten order will indicate that Courtney Daly is approved as a supervisor. That'll be the first item. I'll note that here.
Your Honor, I do have a couple questions.
Go ahead.
When would she start supervising the visits?
His
Effective
next
now.
visit is tonight.
She's appointed as of now.
And I will circulate the signed oath so that both Ms. Schaefer and Ms. Nielsen can sign that. I'll circulate the one that's been signed by Ms. Daly and my client, and I'll just send that to them through Dropbox Sign so they can electronically sign that, and then we'll get that filed with the court.
And then also, is there any way that we can reverse the agreement of email services and make it paper copies, as having it in paper definitely helps me a lot better, especially for court hearings?
I'm happy to provide both email and follow it up with a mailed copy if that's Ms. Nielsen's request.
Yes.
I don't have any problem doing that.
Okay. And then if I also didn't receive a phone call while I was in class from the court clerk, I wouldn't have known that there would have been a court hearing today. I didn't receive a docket notice or anything based on this hearing today.
Well, we were in court on the 12th. I don't think that Ms. Nielsen was present in court on the 12th, but she was in court with Your Honor, who was covering for Judge Hahn on June 11th. And at that time, we referenced the hearing on June 12th. And it was at that hearing then that it was set over to today. So she's found out some way because she's here.
Yeah, because I talked to the court clerk over the phone.
So yeah, I'm not exactly sure what happened, Ms. Nielsen, but you're here today and I apologize for the oversight. I'm glad you were here. So we have Courtney Daly is approved to serve as supervisor. Petitioner, Mr. Daly, shall not consume alcohol or other mind-altering substances 24 hours prior to his residential time with child.
Or during.
Or what?
Or during.
Oh, pardon me. Thank you.
Yeah.
And then this order, other items that it should or should not include. I should indicate that supervised visitation can now commence.
And would you mind also including in there that my office will provide a mailed copy as well as emailed service to Ms. Nielsen?
Yes.
Thank you. I appreciate that.
So attorney for petitioner shall provide service of all documents via email and paper copies.
Thank you.
Any final items from any of the parties?
I will provide a confirmed copy of the order that Your Honor is entering to both parties. And as soon as we're off the line, I will forward through Dropbox Sign the oath for them to sign and then provide them with a confirmed copy once that's entered.
Very good. Ms. Nelson,
would Courtney start supervising as of this weekend?
Yes.
I thought that visitation was Wednesday night.
From my understanding, he is out of town.
So she's approved as of right now. So whenever that date is, she can start doing that.
All right. Thank you.
All right. That'll conclude there. Thank you.